Okay, let's begin. So today we're going to talk about non-signatory issues. That is, when parties that have not signed or that claim not to have signed the arbitration contract may be held responsible under an existing arbitration contract. This issue arises when there are at least three parties, right? Or more than two parties. So what we're talking about is there's A, there's B, there's a contract between these, and somehow there's this C. The status of C is not very clear. It's uncertain. So C is a non-signatory, does not sign this particular agreement. It could arise in the context of A wanting to bring him in, or B wanting him to bring him in, or C wanting to join, but A not wanting it, or B not wanting it. Right? It could arise in all of these contexts. In any case, the issue is the same, whether or not the third party could be bound by an existing arbitration agreement when that third party is not a signatory or has not consented to the arbitration agreement. Now, that question is different from the question of whether or not C has consented. See, that is a separate question. Whether or not C has consented is going to be a question of the existence and validity of the arbitration agreement. If A claims that C is a part of the arbitration contract, is bound by the arbitration contract because C has consented, C has agreed to arbitrate, that is a different question, right? It's a question of interpretation of the contract. It's a question of whether or not C has provided her consent, whether she is a part of that contract. It becomes a third-party issue when consent cannot be proven. Arbitration is obviously contractual by its nature, right? What we're talking about today is when and if a third party who has not consented, who has not signed the arbitration agreement, may still be bound by an arbitration agreement between two other people. That is what is called third party issues. So courts and arbitral tribunals have employed a number of different legal theories to bring in C, the third party, to the arbitration, or to refuse bringing in C because of lack of theory. Here are some of the theories that they've used. There's the alter ego theory. There's the agency, assignment, estoppel, assumption, ratification, implied consent, guarantor. So these are not the only theories, but the most frequently employed theories are these. So these are legal theories to bring in a non-signatory into an arbitration, any kind of arbitration between two individuals. So it's usually the third party that is brought in under any one of these theories. It's enough that you can prove one of these theories to bring them in. So the alter ego theory obviously is corporate law one. It's an equitable relief. It's an equitable doctrine where you will see if the corporate shell has been corporate structure has been abused for a variety of purposes. We will see the details of that from the cases that we're going to be talking about. Agency obviously is a contracts law theory whereby you seek to establish if the person who has signed is an agent of the one who is now refusing to be bound by the arbitration agreement. Assignment is also a contracts law theory if the contract has been assigned to another person. And it's similar to the assumption theory if you have actually assumed the responsibility, contractual or otherwise. Estoppel is an equitable relief, an equitable doctrine, whether you are stopped from claiming that, oh, I'm not a party. We'll see how that plays. Ratification is if you have approved the agreement, but you finally say, oh, no, I have not. Implied consent is even if you have not expressly consented, whether or not it could be implied from what you've done that you have actually consented. And guarantor is if you are a guarantor and the contract is signed between the guaranteed individual and the other, and then the guarantor may at times be held responsible and brought into the arbitration. So these are various theories that could be used to bring in third parties into the arbitration dispute. And secondly, we're going to look at, this also raises an interesting competence or allocation of competence question, right? If it's disputed that C is not a party to the arbitration agreement, if a legal action is initiated or an arbitral case is initiated, whichever comes first, the party that does not want to be in arbitration or the party that does not want to be in court is going to raise an objection, and the objection is going to be that, oh no, I'm not bound by this arbitration agreement. If that question is raised, who has the power to decide whether C must be bound by the arbitration agreement or not? That is essentially a competence question. Does the arbitral tribunal have the jurisdiction to decide a non-signatory must be bound by it or not? Ordinarily, the way the principle of competence works is for the arbitral tribunal to decide its own jurisdiction. Its own jurisdiction over what? Over the parties. Arbitral tribunal decides its own jurisdiction over the parties appearing before it. So if it's a question of the validity of the arbitration contract, the competence basically pertains to, we do have the jurisdiction to decide our jurisdiction rather than the court deciding this for us. But if it is a third-party question, it's the same. They need to decide whether or not they have jurisdiction over this third party, C, on the basis of a contract between A and B. Right? So it becomes a jurisdictional question. In that sense, we have two cases to demonstrate who actually first decides whether or not any one of these theories could help to bring C into the arbitration. Do you let the arbitral tribunal decide whether there is an alter ego, or give that decision to the court first, and then if the court decides, oh, C is the alter ego of B, then the tribunal would have jurisdiction over both B and C. Okay? All right. Let's explore how these principles work in real cases. The first case is the Beredash case. That is 5th Circuit Court of Appeals, 2003. So, Which party is the third party in this case?
Government.
Huh?
Government.
It's the government, yes. Because the relationship between Bredas, which is the company, and the other agency, the existence of the arbitration agreement is not disputed. An arbitration contract exists, an arbitration agreement exists. The question was whether or not the government, as the government of Turkmenistan, is bound by the agreement. The court goes through different theories to establish whether or not the government is bound by this arbitration agreement. So what are the theories that, let's list them first. What are the theories that the court looked at in deciding whether or not the government of Turkmenistan is bound by this agreement? Tell me. Agency is the first one. Second? Alter ego. What else?
Estoppel.
Anything else?
Party decision.
Beneficiary, yes. Okay?
Favor.
Huh?
Favor. Favor.
What did they say?
Favor.
Favor?
Favor.
Waiver.
Waiver.
Yes. Whether or not they actually waive. Okay? These are, I think, what they looked at. Yeah. On the agency question, what are the considerations? How do you decide whether or not there has been an agency relationship between A and C, between the party and the government? What is the first thing they do to decide whether or not there is an agency relationship?
Look at the parties' consent. Because agency is a fiduciary relationship and it needs a manifestation of the consent by one person to another. So the court look at the evidence to show whether the government is consent that this company is his agent.
Yes. So agency is basically a question of consent. And as such, it's a question of contract, right? Whether there is a contractual relationship between the agent and the principal. Whether the agent was acting on behalf of the principal. The relationship between the two is purely contractual. So the agency analysis is essentially the determination of whether or not there is a contractual relationship between the agent and the principal. And to determine whether there is an agency relationship, the first thing that the courts usually look at is what law governs, right? This is the governing law. What law governs the agency analysis? It's contract, right? Because it's contract. Well, you have to find contract law to see if an agency relationship exists. What kinds of agency are you familiar with?
Company.
Huh? What kind of agency? It could be, yes. Employment relationship could actually give rise to an agency relationship. But generally, broadly, agency could be
Express authority.
exactly. Could be express authority. And what else?
Implied.
Implied. Could be implied. Implied or apparent. In each one of these cases, you must look for a particular set of contract law to see if there is a contractual agency principal relationship between the two. Now, did they find in this case there was an agency relationship between the government and the Turkmenian party? When you try to determine that, obviously you need to look at the facts of this particular case, right? Were there enough facts suggesting that the Turkmenian government was the principal and the company was acting as its agent? Okay, 3 pieces of evidence, right? What were they?
Letter. This is a letter.
Yes, there was a letter written by. What does that letter say?
All joint venture capital rights established in the organization documents are fully and completely guaranteed by the government.
See, here we said there's a theory of guarantor. A guarantor could be held responsible. Now we're not talking about guarantee-guarantor relationship, but we're talking about the agency theory. The agency theory would require certain facts to see if there is an agency relationship between whether it's express or implied or apparent, agency relationship between the government and that party, right? One of the pieces of evidence they presented with this letter that actually said the government guaranteed the performance. So that evidence was brought in to show that maybe there is an agency relationship. What else?
They say that they are represented by the government party, Turkmenian party.
So yeah, there is that representation. And there's a third one, probably more important.
The ministry is the Turkmenian party.
Yes, they say the ministry was the Turkmenian party. So they somehow connected all these evidence to show that there was an agent-principal relationship and the government must be brought in. Now, this is the Fifth Circuit Court of Appeals, right? Two questions. First, the simple one. Why do you think that Redes wanted to bring in the government as a third-party respondent? Deep pocket, exactly. It's because that is where the deep pocket is. Have you followed how much money they were awarded? Huh? Exactly. It's $495 million. That's how much they were awarded, right? So the second question, how did they end up before the Fifth Circuit Court of Appeals in Dallas?
That's probably where the oil is at.
Huh?
Is that where the oil's at?
No.
No.
It's this was a contract for exploration in Turkmenistan, not in Texas. But somehow they end up in Texas, and these are none of them is an American company. Did the contract say arbitration in Dallas, Texas? It did. What did it say? Do you find it interesting that they're actually before a U.S. Court of Appeals somewhere in the South?
Actually, they only refer to any disputes that come up will go to the arbitrator, but they didn't exactly refer to the text, I think.
They did not, but I think they selected the seat of the arbitration, and it is actually Paris, isn't it? And under ICC rules, somewhere it says ICC Paris. Huh?
No Paris.
Sweden, yes, Sweden, exactly, Stockholm.
Stockholm.
Stockholm, yes. ICC Stockholm. So that was the selection. And then we find them in Texas. Why?
The parties agreed.
Exactly. The parties actually agreed after the dispute had the reason to move it to Texas. Why? I don't know. My sense is, who are the arbitrators? It doesn't say here, actually. The court case does not tell us. My sense is, maybe the chair of the tribunal actually is from Texas. Sometimes they do that. Or maybe they thought that each party thought that they would have an advantage before a U.S. court. You know, when you relocate the seat of the arbitral tribunal, you have to be extremely careful because it's that court that would have jurisdiction over something like this. This is a claim for what? Confirmation, right? Or annulment. Once they got a $495 million award, what are you going to do? Oh, let's go to court. Make sure that the court says yes. It's only if the court actually confirms it, adopts it, recognizes that's going to be enforced, right? If the court says that, it's going to happen. Because they can seize assets and things like that. So, they moved from Sweden to Texas. And that's why they opt for this Fifth Circuit Court of Appeals. Only because the tribunal is cited in Texas. That is why the U.S. court had jurisdiction over this thing. This is a big award, and they had to go through all this analysis to see if they want to confirm it or they're not. It's a $500 million award. Okay? Now, if the lawyers had done their work very well, when you arbitrate a case in a certain district in Texas, if you do your research very well, you know exactly which judge this thing is going to go for. And if you do a little bit more research, you know exactly what types of judges decide what way on these kinds of issues. Whether or not they're willing to bring in the big guy, the government, or they're reluctant to do that in a business relationship. This is partly ideological. We'll see what happened later on, right? In this analysis. So at first they seemed, the Court of Appeals that is, seemed that they were now willing to bring in the government, right? They said, agency, they did not find it. Despite those letters, despite those pieces of evidence, they say we don't think that there was a principal-agent relationship between the government and this contracting party. And then they looked at the alter ego theory. That's the big one, right? If you succeed on a third-party claim, alter ego is usually the theory that brings in a lot of people. Although the court clearly said that is not a question of contractual relationship. That's an equitable doctrine. And what are some of the factors that you need to look at to see if this entity that signed the contract was the alter ego of the Turkmenian government? What are the factors in an alter ego analysis?
The owner exercised complete control over the corporation with respect to the transaction at issue. And
Complete control and?
such control was used to commit a fraud or wrong that injured the parties seeking.
Yes, those are the two most important factors. Whether that is used for purposes of perpetrating fraud or something that harmed the other party. It's an or, right? It's not an and. It's an or. Which one is and? No, between the fraud and the harm. Right? It's or.
Or,
yes.
yes.
I think it's, so that's important because So there is fraud or injustice or injury to the other party. You can actually cause injury or injustice to the other party without engaging in fraud. So that means you need not, in all cases, show that the corporate separateness, lack of separateness was used to cause to engage in fraudulent behavior. Because if you reduce the concept of alter ego to only fraud, it becomes extremely limited, right? It's possible that you may cause injury without engaging in fraud, right, or injustice. So there's this complete disregard of the corporate structure, and then you use that company to harm another party. And of course, the other party claims that he's being harmed. So in that analysis, there is some very detailed descriptions of how you do that. The Court of Appeals actually gave them some details as to what types of factors that they need to look at in determining whether or not an alter ego situation exists. Was the Court of Appeals convinced that there was an alter ego situation here? What did they do on that issue? Did they decide that issue? Did they? They said there wasn't sufficient evidence, and if there is lack of sufficient evidence, what do courts of appeals do? Yeah, they remand it to the district court so that the record be further developed. And that's exactly what they did. But in doing so, they actually set forth very detailed guidelines for the appeal to the district court to undertake factual findings. What are the details that they provided in terms of what they need to be looking at to see if they have an illegal situation or not?
If there is mingling of funds and directors.
Where are you reading from?
Footnote.
Yes, it's in the footnote. You see, there is a detailed set of factors that the court needs to be looked at. If you look at footnote 5 on page 556, there is at least, 12 factors that the court needed to look at. The commingling of funds, control, ownership, overlap of directors, parent subsidiary consolidation, inadequate capital. Those are the kinds of things that you need to look at to see if indeed one of the parties is the alter ego of the other. Okay, so for that one, they weren't able to make a decision, therefore they remanded it back to the district court. Okay, stop. An equitable doctrine. What are the factors that you need to look at to see if the other party is stopped from claiming that he is not a party?
Whether the party rely on that, the arbitration agreement. I mean, the status of the government.
Yeah, so do you follow the analysis there? They permit one type of reliance and decline another type of reliance, right? They permit one type of reliance on estoppel, but decline another type of reliance. Do you follow that argument? How is it?
Direct benefits.
Huh?
Direct benefits with
So, yeah, look at this now. A and B have a contractual relationship. And this is what I tried to do, that C is the third party that we're talking about. In terms of estoppel, if A wants to sue this guy, bring in this guy and This is the arbitration agreement. And then wants to also proceed against C because C is the deep pocket. Can A claim that C is stopped from refusing to be bound by the arbitration agreement, to get out of the arbitration? Can you use estoppel to say, oh, C is stopped from saying that? He must be in. He must be brought in. The second question, the second scenario is this. B, this is corporate connection between the two. C, B initiates a legal action, arbitration against A. B initiates a legal action against A. A wants to bring in C. Oh, if you're suing me, C must also come in. Right? Is this scenario different from the previous scenario? Or can A claim that, oh, C is stopped from saying, no, I'm not a part of it? A third scenario is C initiates arbitration against A. C initiates a legal arbitration against A on the basis of disagreement. Can B refuse to join? Or can B say, can A bring in B and say B is stopped from claiming that he's not a party, or he cannot be a party to this arbitration? Because there is no contract, there is no arbitration contract between A and C. So all of these possibilities exist. This could initiate, this could initiate, this could initiate. What the court in Guerrero-Ridas is saying is that to apply the principle of estoppel, the party that is stopped must have done something to avail itself of the arbitral process. You cannot bring in someone who has nothing to do with the whole arbitration process. You cannot just initiate arbitration against B and bring in someone, Z, randomly, who's not a part of this, and say, oh, he's stopped just because Z happens to have a relationship with B. So for the principle of estoppel to work, the guy that you want to bring in under the principle of estoppel must have done something to benefit from some arbitral agreement. It's then you can say, yeah, you come in because you're stopped, because you've taken steps to benefit out of an arbitration agreement, whether to sue someone else or to defend against some claim. If you have nothing to do with the arbitral process at all, you cannot use the estoppel principle to bring in third parties. Third parties can only be brought in if they have done something to take advantage of an existing arbitration agreement. not necessarily with the one that is trying to bring them in under the principle of estoppel. See? That is the distinction that if you read that text very closely, those are the cases that they are citing to. Every time that we allow the principle of estoppel to be used to bring in a third party is because third parties have taken some steps to benefit from an arbitration agreement somehow within that context. Collaterally, they stopped from saying, no, we are not part of this one, but we are part of this. That is what we're trying to. So in this case, the government has done nothing to take advantage of the arbitration agreement. They have never initiated an arbitral proceeding against anyone. They are just saying they're not a part of that arbitration agreement at all. In those instances, principle of estoppel may not be used. Does that make sense? I think it makes sense, yeah? That's what they're saying. Okay. Third party beneficiary. Was the government a third party beneficiary of this agreement? Did the court find that the government, being a third party beneficiary, must be bound by the arbitration agreement? Did they say that? I don't believe they said that. No, they didn't. They did not find that the third-party beneficiary doctrine, they say, is distinct. If you look at page 557, the very last paragraph, they indented text. Under third-party beneficiary theory, a court must look at the intentions of the parties at the time the contract was executed. Under the equitable doctrine, a court looks to the parties' conduct after the contract was executed. They're making a distinction there. So the third-party beneficiary analysis under due form that they cited is under, so that they're making a distinction in terms of temporally, third-party beneficiary is about the contract itself, whether the parties initially, when they were making the contract, intended one of them to be the beneficiary of the other. In this case, they did not find that the government benefited from the existence of the JV agreement. The fact that a person is directly affected by a third party's conduct, that he may have a substantial interest in the contract enforcement, does not make him a third party beneficiary. That is the conclusion. The fact that the government ultimately may benefit out of this whole oil and gas transaction does not necessarily make it a third party beneficiary. The distinction being, third party beneficiary does not mean that you actually benefit from the outcome of the contract. What it means is whether or not at the time of the conclusion of the agreement, you were made a third party beneficiary of that particular contract. That is what it is. The fact that, revenue will be raised and, they're going to pay taxes, ultimately is going to benefit the government. It doesn't mean that. It means that when they were concluding the agreement, they intended to be a direct beneficiary of this agreement. In this case, the court did not find that that was the intention to start with. So the government just set up those corporations and let them do the business without it. So at least the initial perception was that. And whether or not there was a waiver, the waiver issue comes because of what? Yes, right? Yeah, the government did not abstain. They actually showed up. They took part in the arbitration. Why? Now the question is, were they waiving their right not to be bound by the arbitration agreement? Why do you think they took part in the arbitration? Yeah, they did object, but actually they went through the merits hearing also. Until the very last, I think they probably hired lawyers and why do you think they did that? This is important. You know, in China, it's very big corporations, the big state-owned enterprises. They are independent business entities, but at the same time, they are wholly government-owned, right? They have their own corporate existence. They enter into contracts, they sue, and they get sued all the time. That these are independent giant corporations. But ultimately, they are owned by the state, right? They are state-owned. If they lose $500 million, the state is concerned about that, right? But it doesn't mean that the state is a party to each and every contract that these guys enter into. So they always watch, make sure that you don't lose that kind of money, because ultimately it's gonna affect the state's coffers, right? That's exactly what the Turkmenistan government was doing. This was an oil and gas deal that went very bad, and partly because of the government's decision. So they were just keeping an eye on what's going on in this proceeding. They hired lawyers to make sure that. Now that was raised as waiving their right not to be a part of the arbitration contract. That's the waiver question. By participating in the arbitration proceedings, you have actually waived the objection to the arbitration agreement. That's what they were saying. And of course, the court did not agree with the waiver argument, and they said, I understand that they were following things, I understand they objected to their jurisdiction of the tribunal, but the fact that they participated does not mean that they waived their right not to be a part of the arbitration agreement. That's what they usually decide, right? Is that convincing? Do you think they actually waived by taking part in the arbitration? They knew at some point that they were going to be responsible directly. Now, the decision on waiver is actually an extremely important one. If the court had found that they waived the right to object to the arbitration agreement, if the court had found that means they would be directly responsible to pay the $495 million. Who would be responsible for that? The state itself would be directly responsible for that. If the court said, no, they did not waive, despite the fact that they participated in the proceedings, they did not waive the objection, it means that they are not responsible for the payment of the $500 million award. Then, what would the company, Bredas, what would have they done if they're not allowed to enforce it against the states? Their chances of recovery would be limited to what?
The asset of the enterprise.
Exactly, the asset of the enterprise. There was it. Yes. The asset of that particular enterprise. If it is $100 million, that's it. If it is $26,000, that's it. They're done. That's why it was so essential for the company to bring in the government, because governments always have money. That is true. So it's not an easy dispute. It's an extremely important one for them. So when the court decided that they took part in the arbitration because they are another government, but that does not mean that they actually waived their objection, because they actually said that they objected to the arbitration. Now, so they struck down all of these theories one by one. Agency, no. Stockhold, no. Third party, no. Waiver, no. The only thing that was remaining was alter ego. Alter ego was remanded to the district court. Now, what the district court did was what any reasonable district judge would do in this case. What is that? Found no alter ego. Why do I say that? If I were the district judge, I would have done exactly that. Why?
The judge intended to say no to this
Exactly. They set it up exactly like that. Anyone who actually reads this opinion would not think that this appeals court wanted to hold the Tasmanian government responsible. They say no to everything. So when they sent this back, you would assume that they wanted you to say no to this as well. And that's exactly what they did. Were they not surprised? What did the appeals court do? They told them to say no, and then when they said no, they reversed them. I thought that was really interesting. They collected all the evidence, and they found no alter ego. And then suddenly the appeals court said, oh, on the basis of the evidence that you collected, we think that you erred in your decision. What happened? Who knows?